Me Guyana, land of many waters with 6 races living together.
Globespan is a Guyanese dialogue moving towards the realization of one nation in one Guyana. It's a platform that offers an all-inclusive discussion, with the pros, the cons, the ones that is taken aside, and the ones that stand in the middle. Globespan believes agreeing and disagreeing are part of the nation's building. Globespan believes that every Guyanese voice is part of the nation's building. As we span the globe for voices from the diasporas and those living home, we stand on our commitment that we are all Guyanese working towards one nation in one Guyana.
Coffee and Dr. Jagan, Bobby, she gave us our great sons. Rohan Kanhai, Coffee and Dr. Jagan.
As the world turns on its axis bringing changes, we as Guyanese must adopt to those changes for a better Guyana for all. Globespan stands on its axis with its belief that one nation, one Guyana, one destiny must include voices from all corners of Guyana.
Land of many waters with 6 races living together.
Good evening to all our viewers here in New York and across the world. You're listening to Globespan Television live. This program is made available by Mr. Noir Singh and by our technical directors, Mr. Devin Bissoon and Mr. Ryan Gobin. We can also be heard on Globespan on YouTube and on Facebook. So tune in there, you'll be able to listen to us. I want to remind all our listeners and all our viewers that the views and opinions expressed by our guests do not reflect those of the staff and management of Globespan Television. Tonight's topic is very, very important. It's what we call separation of powers, and we'll deal with the teacher strike and those things after. But the separation of powers is vital for any democracy to survive in Guyana. And we have 2 outstanding guests to deal with this issue. We have Attorney at Law, Mr. Timothy Jonas. He's also the General Secretary for the ANOG, a New and United Guyana Party. And we have Dr. Blackman, Professor at Medgar Evers College in Mathematics. Good night, gentlemen, and welcome to Globespan.
Good night. How are you doing? Thank you to you and your viewers.
Thank you, Asper. Thank you for having us. Good night to you.
Good night. I want to just start off before I go to anything else. And I want to ask both of you, especially you, Mr. Jonas. Mr. Ramkaran has called for a revision of the Constitution where the executive power should be lessened. I glanced at it, but I didn't see what he was actually saying. Mr. Jonas, can you explain what powers he wants to be lessened from the executive, from the presidency?
You caught me by surprise there, Asper. You're asking me to speak for Mr. Ramkaran.
It was published in the papers, but I hadn't time to read it extensively.
I really don't want to do that.
Okay. Let's move on then. First, I want to talk about, I don't want to talk about this because this is a different topic altogether, but I just want our listeners to know that there's something called divided government, and it exists in presidential systems where the control of the executive and legislative branches of government are split between 2 different political parties. And normally this will lead to compromise, which is beneficial. It exists in the United States and a few other countries. I just want our listeners to know that divided government and separation of powers are 2 different things. Now, Mr. Jonas, let me ask you, what is separation of powers?
Okay. If you don't mind, I'm going to give you the long answer with the historical reference, because I think it's important for people to understand why it evolved and why it's useful. Now, long ago, we're speaking about Europe, of course, you had a king. He became king by might of arms. He had the biggest army, and if there was any competition, the victorious army, and the leader of that victorious army was the king. Now, a king rules by decree. So
right.
his decree is a law. He says women shall wear long skirts, and that's the law. He also has the power to be judge. So he can look at a woman on the road and say, your skirt is not long, and he can convict her. And then he can take his sword with which he has defeated the other army and therefore become king, and he can cut off her head as executioner because he decided that her skirt was not long enough and that she had therefore broken his decree as to long skirts. So we got the expression judge, jury, executioner. All of the power resided in the king, and the king was the state. The French say, l'estat c'est moi.
Oui.
The state is me. So when people spoke about the king, they would say the king's justice is harsh. They're not saying that he's unjust because he's the king and God appointed him to make the law, run the government, and do everything. Now, in the 1600s in England, as the middle class, the merchants, the entrepreneurs, the bankers, as they got more powerful, there was a civil war. And that power of the king was diluted by virtue of that civil war, that revolt by the citizens against the absolute power of the monarch. And what evolved was a system of laws imposed by the successful citizens that separated the lawmaking body, which is Parliament, from the government, which continued to be operated by the king, the monarchy, and assured an independent judiciary. It's a nice system. It's got flaws, but it's the best system that I can think of. Parliament creates laws. Parliament says women must wear long skirts. The government is there to administer the country in conformity with the laws. So the government police might say this lady's skirt is not long enough. And then the government can't punish her. They have to take her to the judiciary, the judge, who tries her, and the judge is the one who decides if the law has been broken or not. So you have a separation of the powers that were previously all held by the king. And that's intended to create fairness, to create transparency, and to avoid the absolute power that we know is so dangerous and so corrupting.
Yeah.
I don't know if that explains it. I can give an example. Therefore, when Parliament passed the law, changed the constitution to say that a president can only sit for 2 terms of office, in order to construe that, somebody felt that law is not clear, and I don't think it applies to Mr. Jagdeo. And therefore, an application was made to the judiciary, the judges, to construe the law that had been passed by Parliament to decide what is the correct approach and whether this member of the executive was entitled to sit for another term of office. And that separation of powers is what gives us a justice system that, if it's working smoothly and if the wheels are well oiled, is the best system of running a country that I can conceive.
Okay. Just for our listeners to know, the separation of powers means that a state power is divided between 3 branches of government. The executive branch, which is the president or prime minister, the legislative branch, which is parliament, in Guyana's case, the National Assembly, and the judiciary, which is the judicial system. Now, all 3 branches are ought to be separated from each other. The legislative branch, the executive branch does not make laws, but it executes and enforces them. The legislative branch makes, enacts, amends, and repeals laws. And the judiciary branch interprets and applies the laws as necessary. Now, Dr. Blackman, do you think that we have an independent parliament in Guyana?
In the sense that our Parliament, as it's currently configured, is independent. Well, I mean, it's difficult to construe it as an independent parliament simply because the the ministers of the government are members of parliament. So I mean, immediately as I listen to you, the executive and the legislature are intertwined within the context of the Guyanese government. So no, it's not independent in that sense, but it is the history that we've you know, I don't think we've ever had governments in Guyana where, you know, in a sense the ministers and the other functionaries of the government were not members of parliament. You know, Attorney Jonas can correct me, but that as far as I can recall, that seems to be the system that we've had in place.
Mr. Jonas, in a parliamentary system, the governing party controls the legislative branch. Do you think that should be changed and make it more independent? In that case, it's not independent because the party with the most seats will have a say as to what to do in parliament. Do you think that should be changed? And if so, change to what?
Well, I don't think that that's automatically the case, is it? It happens in Guyana because usually there are only two parties contesting any election, so that the party that wins also will have most of the seats in parliament. But that's not necessarily the case. If three parties contest, as the AFC did back in 2011, the winning party might get government but might not control parliament. Parliament may remain independent of that winning party. And to me, that is the ideal situation to ensure true independence of parliament, true separation of the legislature and the executive.
How effective, Mr. Jonas, is our parliamentary system of government in Guyana?
Okay, now that's a practical rather than systemic question. Yeah. And from a practical point of view, I have found that Parliament has consistently been the tool of the government, performing at the whim of the government, and laws being passed because the government says so. So from a practical point of view, Parliament should close up shop and those 65 people can all go home because the 32 people in opposition are completely powerless to stop anything from happening that the majority in government of 33 seats wants to happen.
Yeah, no, I broadly agree with that. I think that this. No, I broadly agree with that. I think that is, you know, that is the fundamental challenge. One of the fundamental challenges facing Guyana, that, you know, the space for a proper, robust, rigorous debate on policy is completely absent. Right. So the government decides that this is the policy, and you know, the space for amending that policy based on some discussion is almost non-existent. You know, it's unfortunate, but that is what we see from a distance. And so, you know, I think maybe that's something that we ought to be thinking about. What are some of the ways in which we can mitigate this harsh winner-take-all 33 versus 32, right? I mean, we've seen the debates, we've seen the sort of strident screaming, we've seen the kind of almost unseemly behavior, but I think it's a function of the fact that, you know, there's really nothing that one can do if you're sitting on the side of 32 that allows to impact the policy in any substantive way. So that's definitely something that I agree with.
I'll go further, you see, because we bring up red herrings. We say we need a robust opposition, a strong opposition. If the opposition has 32 seats, there's nothing they can do. So there's no meaningful way to be robust or strong because they lose. You pass a law in Parliament, Public Procurement Act, no penal clauses, designed to be evaded, and there is nothing that the opposition can do, even if they had the competence to pick up the flaws in the act, which clearly they didn't. So as long as government has 33 or more seats, it is useless, it is silly to try to talk about some active opposition or some opposition that's strong or robust. That's nonsensical. The other thing I want to say before it even comes up, and Dr. Blackman touched on it, which is why I want to get there immediately. Don't let us pretend that we should have a discussion about changing the Constitution to change that. The party in government will never change the Constitution to change that. In fact, I don't even think the large opposition will change the Constitution to change that, because they're just holding their breath till the next election open. They can get absolute power. And I want to make the point that the only constitutional amendment that was made relevant to that was the amendment made to the Constitution that permitted the leader of the list, so the leader in the PPP, the leader in APNU, the leader of their list, their respective lists, putting names into Parliament, the power to inform the Speaker of the House that he had lost confidence in any specific parliamentarian, and therefore that parliamentarian could be removed and replaced by the Speaker. So if they had any fear that they had a Charandas sitting there, they can inform the Speaker and remove that Charandas to ensure that there is compliance, that there is obedience by the people that they have inserted into Parliament to carry out their will. So the only change that has been made has been to strengthen the hold that the party has on the parliamentarians, rather than to relax that hold. So I want us to avoid falling into the trap of having a discussion if the Constitution needs to be changed. It'll never happen. That will require both parties to agree. We have to find another way to solve the problem.
But why do you think both parties do not want change in the Constitution, Mr. Jonas?
Because between 2015 and 2020, APNU had absolute power with 33 seats. And between 92 and 2015, and again now, PPP has absolute power with 33 seats. And how on earth, who reasonably can expect them to voluntarily give up that power and share with those evil, corrupt, terrible people on the other side of the floor in Parliament? It's an impossibility. We shouldn't even go down that road. It will not happen.
So how do you think it should happen? How do you think it will happen?
You're asking for a solution.
Yeah.
To me, the only solution lies not in constitutional reform, which I have decided is an impossibility because the two parties will not agree. It lies in a third party doing what AFC did in 2015, which is giving to the opposition control of Parliament so that the opposition can influence those laws. And what it will need, and the AFC specifically did not do it, let me hasten to say that, they didn't pass a single useful law in opposition when they had the majority in opposition. They betrayed the trust of the people who supported them and the entire opposition. But a competent opposition majority in Parliament can pass the laws in Parliament to ensure transparency. It could pass the laws, we get in blackout. It could pass the laws to say, we put in our people on that board. We're getting rid of the government people on the board, and we are managing the award of contracts and the award of responsibility for generation in GPL. We're taking it away from the government. No more secret deals. It could do that with Kaiwa. It could do that with road building. It could do that with any expenditure. It could do that with public procurement. A third party needs to be there to allow the opposition to control Parliament. And that is the solution to the problem.
You are a member of the Constitutional Reform Committee, but it just dawned upon me to ask you this question. Is there anyone from outside of Guyana or from the diaspora a member of that committee? Do you know?
I don't believe so. I wouldn't like to put my head on the block, but the names I'm thinking of, working from memory, I think they're Guyanese in Guyana.
Okay. Now, the judiciary, it is based on the Constitution, it is supposed to be an independent body to interpret and apply the laws of the country. Now, Dr. Blackman, do you think our judiciary or judges are doing just what the Constitution states, or they're doing something else?
You know, I think we have a long tradition of excellent sort of jurisprudence in Guyana. But I think I would, you know, I would hasten to add that we do know of a number of ways in which the judicial system has not always worked in the interest of justice. In cases, members of that group have subverted justice. So, I think it's a mixed bag. We can be proud of having some of the world's most learned jurists, and we can be proud of a relatively stable, and I mean, I think as we noted, Judge Kissoon, most recently in some of the rulings that he has made in relation to this teacher strike, certainly demonstrates a kind of independence. But we also know that that independence is not completely broadly shared across the entire judiciary. So I think it's a mixed bag, but I would say on some sense, I think Guyana's done a decent job, but we know, and we would be kind of not honest if we didn't speak to some of the challenges that impact our judiciary. I mean, I think if I were to say one really good thing is the fact that we're part of the CCJ is our highest court, and many a time I've tuned in and listened to the arguments on the CCJ by our Guyanese jurists, and I've felt very proud about this. I've actually listened to Justice Saunders once he visited here at the college, and so quite taken by him, and I have spent some time kind of following the court, so to speak, and so I do think that we have a judiciary that has the right aspiration, but as we know, we've not always met the bar, and all of its members have not always met the bar that we hold for a judiciary across the board. And I suppose maybe in other countries this is not dissimilar from other countries.
By the way, I did ask a number of members from the ruling party to be with us here tonight, and they've all refused, citing different reasons. So those of you who texted me and asked me why I didn't get someone from the PEP, we have tried, but no one responded positively to us. Now, Mr. Jonas, in every country, the small man is all being treated differently based on the laws. For example, I just completed a book on President Obama, where he cited that he had to equalize the system because if a black kid is caught with cocaine, he will get 5 to 10 years in prison. A white kid got caught with cocaine, then we give a suspended sentence or 6 months in prison. But Obama make it such a law that the judge has to apply it directly as it is, which was something good to equalize the system. But what President Trump is doing in the States, it shows that the United States has a two-tier system, one for the rich and powerful, and one for the poor and the powerless. In Guyana, that same system exists?
No. I resist any comparison between Guyana and the US or the UK. They have their peculiar problems. They have a minority group that is outside of the economic power, outside of the political power, and really is no meaningful threat to the establishment. If you just look at the simple percentages, numerically speaking, the minorities are a small percentage. If you look at their economic strength in terms of financial control, they're a small percentage. So it is important in those countries for there to be measures to ensure that their historic tradition, culture of ostracism and exclusion and preference is removed. And let me say, power to them. They've made great strides. With people like Malcolm X, Martin Luther King, JFK, they have done great things. And a lot more needs to be done. But you see changes. England has done better than America. I used the example the other day that in the 40s, when Brown and Ministry of Education, Board of Education in England, in the States, was still justifying segregation in schools, us Guyanese, Black and Indian, were going to Queen's College and Central High and the best schools and receiving exactly the same education as the children of white colonists. This is back in the 30s and 40s. So the English were a step ahead, but the problems that continue to exist in America and England in terms of endemic racism, systemic racism, ostracism, I don't think should be compared to Guyana. Guyana, for 50 years since independence, has not had any large, numerically superior, militarily superior, financially superior group ostracizing the other group. We've been oppressed by our own people, both PNC, both PPP, PNC, in their various manifestations. Those are our oppressors. And I think we need to avoid comparisons with the states.
Okay. Well, I wasn't making a comparison really, but I got a text here, and this person is telling me that if someone is pulled over in a traffic mishap somewhere, and that person is poor, that person's vehicle will be towed to the station or go to the station, or the person will be charged, given a ticket or whatever it is. But if it's a rich person's child or a rich person, they call someone, and that what person someone will speak to the police officer, and he or she allowed to go freely. Are you aware of that?
Dr. Rose, I mean, I can't speak to this specific, but I think as Guyanese, I mean, we're fully aware. Look, if you're rich, it will affect the access to the kind of legal representation that you have. We can speak to a number of the cases that we've seen across the docket in relation to high-profile individuals who have had access to extremely good legal representation, and we've seen also cases of people who don't have the kind of access to that. We've seen many of the situations where people's cases take a long time for them to, these sort of backlog type things, right? It takes a long time for them to get to court. If you're poor, then it's likely that this is going to be the case. I mean, these questions that we just raised, that I kind of brushed on, the questions of corruption and transparency, I mean, those are certainly questions that are affected by whether or not one is wealthy or one is poor. These are realities. Attorney General speaks to questions of bias and discrimination as they exist in the United States, and that's certainly a case. And I think many of us are aware of those issues as they relate to the American justice system. And you mentioned some of the fixes that President Obama aimed at kind of mitigating some of the challenges, particularly faced by African Americans in the justice system. But I think similarly, systemic biases, discrimination exists in Guyana, maybe not always in the question of race, but certainly socioeconomic status, ethnicity, and these manifest themselves in judicial proceedings, right? So, I don't want to, discuss the litany of things that one sees in the newspaper, but I think we can reasonably construe that, there is bias and discrimination in some aspects of the Guyanese judicial system, right? So it's not to your audience members' observation. The answer is yes. I mean, it's sometimes when actually, but I have a funny thought. So I remember once being at home and being stopped by the police, and I was smiling with my host at the time, saying, if we were stopped in a dark night in Brooklyn, I would not be as happy as us being stopped in this moment. So, Mr. Jonas is right. There are some different kinds of biases, but they exist in Guyana in a particular way. So I wouldn't make light of it. It's there, and it's something that we have to work on in a systemic manner.
Mr. Jonas, you being an attorney of law, Ghana has the judiciary has a system. The magistrate court is the lowest, followed by the high court. Is there a Supreme Court in Guyana, Mr. Jonas?
The High Court is the equivalent of, well, all right, you've attached a label, and I think for most people a label will be meaningless. I know in the States, when people talk about the Supreme Court, they have a concept in mind. There's one Supreme Court, which is the highest court.
No, but also they said after the Supreme Court is the Court of Appeals. But I don't know if Ghana.
When you ask me if there's a Supreme Court,
right,
I don't want people to conflate that with the U.S. concept of a Supreme Court.
Right.
So we call our High Court the High Court of the Supreme Court of Judicature.
Okay.
It's a High Court.
So it's one of the same.
There's another tier of appeal from the High Court to the full court. There's another tier of appeal to the Court of Appeal. And then the final tier of appeal is to the CCJ, as you just mentioned, which is the highest court.
For our listeners, can you explain to them what the magistrate court, what cases go to magistrate court, to the High Court, and to the Supreme, and to the Court of Appeals?
Well, that's dry and I might put some people to sleep, but I'll try and do it as quickly as I can out of deference to your request.
Do it as quickly as you can. Because sometimes our listeners don't know, they believe that only traffic tickets and small cases like marijuana will go to the magistrate court. But you have more cases that go to magistrate courts as well. But you take the honor to explain that.
Okay, well, as a starting point, they're right. The magistrates deal with the small matters. But for the more serious offenses, murder, rape, treason, manslaughter, that kind of thing, there is a process traditionally, which I don't necessarily agree with, and it's being eroded. They're passing laws to kind of phase it out, where before it is decided, if you're accused of murder or rape, before it's decided that you should go before a jury for a trial, a magistrate conducts what's called a preliminary inquiry to decide if there's sufficient evidence to commit you for a trial. So it changes what is a singles process into a two-stage process. So the magistrate's function is involved in the serious offenses, but only for the purposes of a preliminary inquiry to see if the evidence against you is sufficient for you to be tried before a jury of 12 of your peers.
And what about the High Court?
Well, that is where the trial before a jury happens on felonies, more serious offenses. And the High Court also is where claims for monetary compensation or claims for land or trespass or breach of contract or any of that happens for sums more than $500,000. The magistrates deal with the small sums. And the High Court is also where you can go for protection under the Constitution if the government takes your land. And there's an interesting history about that, actually, Asquith, which explains why Burnham, when he was president, abolished the Privy Council as our highest court. And finally, the High Court is available for judicial review cases where it is felt that the government is exercising its power, or ministers or other government departments are exercising their power in a way that breaches the law. And the court has jurisdiction to assess the exercise of a statutory power and make orders to correct it if there have been breaches of the law.
Could one appeal a case from a magistrate court to the Court of Appeals, or it has to go through the process?
An appeal from the magistrate goes to the full court.
Okay. Okay.
You know, Dr. Rose, I wanted to add one other thought. I'm thinking of my role in this program now as a sort of diaspora person. And as we were talking about these questions around the judicial system, and I'm reflecting on issues related to the judicial system here in New York. As an undergraduate, I was part of we had a kind of judicial office at the college. And there are a couple of things which it strikes me that as we have this conversation around Guyana, and so maybe Mr. Jonas can comment. So questions of legal aid, like legal services to kind of ensure that poor individuals have access to affordable legal representation? I mean, what's sort of along those ways? So as we talk about these questions of judges and, you know, potential issues of bias and corruption and so on, you know, what's the regime protocol around questions like judicial training? You know, is there some ongoing thing that, you know, judges are a part of that kind of, you know, that speaks to how to manage these kinds of things? And then two more, which I think are important, you know, and which comes from the experience in this context. You know, are there like sort of like outreach things which bring the sort of, you know, like Attorney Jonas was just articulating, you know, what's the difference between the magistrates court, the high court, the court of appeals, the CCJ, and so on. There's kind of like broad community education about the judicial system is you know, to kind of give us sort of, you know, a legal literacy to the society so that people know what the rights are, how to affirm those rights, where they ought to go, where they ought to be going. That would be something to see, you know, from a distance looking in. And then the last thing I would say, you know, as you know, one of the things that are always, just yesterday, a part of our business around strategic planning and so on, is this business of sort of the infrastructure for how we run the college, right? The technology, etc. And so I think another issue I would want to put into this discussion, since we're talking about it's like infrastructure development for the judicial system, like how to you know, what's the technology? Can people call up all of the cases? So if someone is a lawyer in Latam, is this easy or is this hard? Someone is a lawyer in, you know, the Mazaruni, or is, you know, that sort of thing, I think would be, you know, I don't know what the state of play is at home, but certainly I think questions of legal aid, questions of, you know, how do you kind of do professional development for the judiciary, and how does the judiciary interface with communities near and far in Guyana? And then finally, like just the infrastructure of the judiciary, the courts, the buildings, the wireless connections, etc., so that it becomes in itself a better service, right? So if the goal is part of the conversation to make it better, these are some thoughts, you know, coming on the heel of, you know, you asked me about bias and discrimination. Okay, so yes, I admit, but then what are some other issues that can mitigate questions of bias and discrimination? And so I thought I'd just add those to the conversation. I don't know to the extent to which, you know, legal aid and things like that are a part of the Guyanese judiciary, right? So we mentioned poor people. What is the access to lawyers? Are there free lawyers that are available? You know, something for us to think now as we move forward.
You took the word out of my legal aid. Mr. Jonas, is there a legal aid system in Guyana? If a person is poor and can't take a lawyer, what happens?
Right. Again, another important question, but dry, but I'll answer it as quickly as I can. I take some pride in the fact that legal aid in Guyana was actually designed and commenced with the instrumental assistance of Miles Fitzpatrick, Senior Counsel, who is the founder of the firm which I now lead. He was my mentor when I was a young lawyer, and I worked under him for many years. And in fact, when I left Attorney General's chambers as State Counsel and went into private practice, it was on the terms that I spent the next 5 years working at Legal Aid, which was at the time and still is a Mirage building in Charlotte Street. Legal Aid has grown. It has extended its service, the range of its service. When I was there, I was managing counsel, and there was one other counsel at Legal Aid with me. I think now they've got 5. Under the auspices of Josephine Whitehead, Senior Counsel, who has diligently continued to help and nudge and nurture Legal Aid. Minister Manik Chan, who is a lawyer, also has shown support for Legal Aid and has helped where she could. So the Legal Aid has been functioning and has been functioning quite well, offering a service to the society since the 80s. So that where, for example, we focused a lot on domestic violence, and because what you find in the society, especially in the poor in the society, the vulnerable are the ones who can't afford lawyers and therefore are weak and at a disadvantage in court. So a lot of mothers, a lot of wives came in, a lot of issues like that that we helped with, a lot of small claims, some large neighbor oppressing you and trespassing on your land. We did a lot of that kind of work. And I will say that Legal Aid now continues to do good work. And they are led by some committed lawyers. And I know that they are strong now, and I hope that that continues. Now, on another side, an accused person, a person accused of a serious offense, is entitled to be represented, and therefore the state does have a machinery to appoint lawyers to represent defendants in criminal proceedings in the High Court. Whether or not they can pay for it, the state pays for it. So there is also that procedure. You know, we talk about the separation of powers, and with our usual distrust of the system, and it's a justified distrust because in Ghana nothing works. So you talk about police stopping you and you know nothing works. You talk about going into NIS or any other institution and nothing works. So the judiciary will be viewed with the same skepticism because nothing works. But we have some hardworking judges there, and they are doing their best. And insofar as the machinery of justice is slow, and insofar that I will acknowledge that it is susceptible to interference, there are hardworking judges who do an honest day's work. And I want to remind everyone that of the three branches in the Westminster system, it's only the judges who have to get a law degree and be admitted as a lawyer and have 7 years at the bar before they can qualify to sit where they're sitting. In Parliament and in government, you don't need any qualifications except a silver tongue to convince the people that you're not lying and they must vote for you.
I like how you put that, a silver tongue. Now, Mr. Jonas, they said justice delayed is justice denied. And you know, some people are on remand for 5 years. One, I read a case sometime back last year. A guy was on remand for 10 years and he was found not guilty. Does it? I'm dealing with the judicial system here. I'll get back to the other two systems just now. But will the state compensate him?
I don't know the answer to that. Sometimes it's the delay is so extraordinary and inordinate that there is a breach of constitutional rights. But that is the system. Now, what you're saying is right, but that is akin to blaming a doctor because the health system is bad. The health system is bad because there are no facilities, there's no equipment, there's no proper training, there's no administrative structure. The judicial system is not working because you have, and have for many years, had a complement of between 9 and 12 judges doing the work of 25. Twist it or turn it. The best judges, the most hardworking judges, we got judges that got high blood pressure and sick and coming to work. They're working 8 to 10 hours a day. 9 people cannot do the work of 25. And Guyana actually needs more than 25 judges because we're litigious. We are more prosperous now than we used to be because of gas and oil. So there's more work in the court. There are more matters filed, thousands of matters, and 9 judges trying to hold this up. To blame a judge because the system is slow is just as unfair as to blame a teacher because the education system isn't working. It just doesn't make sense. We have to understand the cause of the problem to solve the problem.
Let me just get back to you on this. Dr. Blackman, just bear with me on this. Is there a law in Guyana which states that a person should have his or her case completed within a certain time frame?
No.
Would you put that in the Constitution?
No, because it's simplistic and it does not address the problem and it does not solve the problem. You are saying this case took 5 years, it should take 1 year. So we're going to make a law that a judge must finish a case in a year. You haven't yet dealt with what I just said, which is that 9 judges are doing the work of a complement of 25, and the complement should be 35. So how do you fix that? You know, we have a strange mentality in Guyana. We say too many accidents on the road. So let's solve the problem by passing a law that you must drive at 50 kilometers an hour on a 4-lane highway. That doesn't solve the problem, Asquith, because nobody obeys an unfair law. We learned that when Burnham banned flour. Nobody obeys unfair laws. If Parliament doesn't have the competence to pass a law that addresses the problem, understands the root cause of the problem, and therefore fixes it, then our problems will continue.
So you're saying that there's supposed to be 25 judges and we only have 9?
Don't hold me to 9, but I know we don't have 12.
Okay. Okay. Mr. Blackman, what do you think? Should there be a reasonable time when a person should be given a trial?
Yeah, I mean, I was surprised. I mean, if I'm not mistaken, I know that there is certainly within the U.S. setup, there is a right to a speedy trial.
Yeah.
I have to go check and see, you know, which one of the amendments, etc. There is some right to a speedy trial. So, you know, certainly, you know, there should be some expectation that you can't hold me forever without having, as you just described, right? There should and these are the kinds of things that I think I noted earlier that we are aware of. And I kind of euphemistically said, well, you know, this question of backlog, but we are certainly aware of that. But I did not know that we did not have some right to a you know, a relatively quick trial. And if I'm not mistaken, this is the kind of thing that is, you know, if I'm not mistaken, this is the kind of thing that one would find in some convention on human rights, the right to a fairly quick trial. So I would sort of say to Mr. Jonas, yes, you know, one needs to ensure that the mechanism for ensuring a speedy trial is in place, i.e. that the right complement of judges are available. But I think one also needs to document very clearly in some place, in some constitutional place, that there is a right to a trial. I mean, you know, so for example, someone could be in Guyana and I could be arrested for a crime, and you know, it could be just an arrest, and I could be held for 10 years, for 15 years, for 20 years. How long would it be, right? So there has to be some clear guidance. I mean, you know, 6 months, 12 months. Yeah, I in the American context, there is a right. I will look this up when I'm finished with this program. I'm sure I read that someplace, and I know that that's the kind of thing that is part of conventions on human rights. And so I can't see that, you know, even if we don't have the machinery to do it, it should be there enshrined, that it is aspirational, so that we're focused on getting, so that things, you know, so that there's some consequence for having someone, you know, wait, as you just described, for years before finally coming to a trial, particularly in a case where someone could be innocent. You know, as the laws go, it's better that a guilty person go free than to have an innocent person lose their liberties over an extended period of time. So, you know, just purely from a math standpoint.
Yes, I don't think we're seeing anything different, Doc. It is tragic and it's inexcusable, the delays that take place. But all I'm pointing out is that the solution is not to be found in simplistically saying you got to do it in 3 months.
Yeah.
And I'll give you an example, because I'm aware of specific examples.
Yeah.
I remember the Chief Justice, before she was a Chief Justice, insisting that a defendant who had been brought before her and who the office of the DPP did not want to proceed with that session. The criminal court works in sessions. So on a particular session, in this criminal session, so this criminal assizes, the number of defendants that come appear, and the court decides it can deal with 20, and it deals with 20. Now, the office of the DPP has a bit of leeway to decide we'll deal with these and not with those. So though the others got to wait for the next exercises. Unfortunately, we have seen evidence where that discretion is exercised, where they don't have the evidence to deal with those folk. So people are put back on remand and put back on remand, assizes after assizes. And here's the silly thing about it. If you don't have the evidence now, chances are you will not have the evidence next year. Witnesses migrate, they die, memories fade, things change. So I know of 2 occasions where the judge has specifically ordered that we are going to try this person because he has been on remand. There's one Amerindian gentleman who learned to speak English on remand. And when the judge insisted, the DPP's office had to admit they did not have the evidence and the person was released. Now, I can tell you that I was specifically offended in one of those cases, which dealt with the father of a friend, somebody I considered to be a friend, who had been charged with murder. No evidence, no proper evidence, but a magistrate, by some miracle, committed him to stand trial, and he was on remand for years. And when the DPP's office finally had to admit that they did not have the evidence to present to the court for the trial, so that he was let off, he was acquitted, the judge said to him, I hope you've learned a lesson from this. Now, I would have put that judge on remand, because what lesson do you possibly learn if you are innocent, arrested by the police, put on remand, kept on remand one session after the other session after the other session, and then released finally after years in jail because there's no evidence against you? The only lesson you learn from that is that the state is failing, the institutions are rotten, and those officious people start sitting up there are self-important and useless. That's the lessons you learn. That needs to change. Fortunately, it's improving because the judges are much better, much more hardworking, but the problem still remains at the root cause, which is poor investigation by police, poor record keeping, poor arrangement of evidence and presentation of evidence, and a DPP's office that is still susceptible to interference. So there are a lot of dynamics, a lot of variables that affect this.
Yeah.
Now,
It's not a simple matter of how quickly can the case be tried.
Right.
If the policeman doesn't have the evidence, half the time, in fact, more than half the time, 80% of the time, is the prosecutor that comes to court to say, my witness isn't here, my evidence isn't here, we've had this problem. Who do you blame when the trial takes a year? We are still waiting for the trial of some political people who were tried for electoral sabotage since 2020. That trial has been going on for years. Who's to blame? The magistrate? We cannot deal with this thing simplistically. You don't just say you got to decide it in a year. Doesn't make sense.
in the United States, there's no federal law to say a trial should take place X amount of days, but it says a reasonable time. And that interpretation means within a year. Now, each state has their own local jurisdiction, but they also maintain what the federal jurisdiction says about a year before you go on trial. So that's the length of time you'll wait, unless they're still waiting on evidence or something of the sort. It will be delayed, and that delay means that the person should be on bail if he's not a threat to the states. So that's the system in the United States. Reasonable time means at least 1 year. Now let's go to Parliament, and I want to ask both of you this question. We have 65 members in Parliament. But Mr. Jonas, as you know, and Dr. Blackman, as you know, certain laws to be passed in Parliament requires more than a majority of 28. All right, no, that should be 33. Sorry.
33.
And I'm supposed to be a mathematician, but something tricked me there. Now, the thing is this. Some laws, though, require 2/3 majority in Parliament. And that's what the separation of powers gives to us. This means that the government in office, whichever government that is, will have to negotiate with the opposition in order to get certain laws passed. Just as to appoint a chief justice, to or to confirm a Chief Justice and make them permanent and not acting on a commissioner of police and a chancellor and so forth, the opposition must agree with the appointment. But let's go back to Parliament. Mr. Jonas, can you tell me or tell our listeners what type of laws are required for a two-thirds majority in Parliament? Do you know?
Only constitutional amendments.
Only that?
That's all. Any other law, short of the Constitution, just requires a majority. This is why the third party is so important, to give the majority to the opposition.
If someone wants to change GCOM or get rid of GCOM, well, that goes to the Constitution.
Well, GCOM is a constitutional body.
Right. So that applies to the Constitution. So only constitutional items are required for two-thirds majority. Other than that, the governing party can pass any other laws.
I'm afraid so.
Well, you're in that committee. I hope you make some valuable changes for the people. I don't know how you're going to do it, but I hope.
That's because, again, we're moving away from what we know to be true, and we are talking about simplistic and unhelpful red herrings. The government, in their 2020 campaign, said constitutional reform. All opposition parties at election time say constitutional reform. It's taken them 4 years to put together a committee. I'm sure you're all familiar with the saying that if you don't want something done, appoint a committee.
Yeah.
So 4 years to appoint a committee. Now, if you want to change the Constitution, what you do is you present a draft that you want and let people discuss it. I promise you that's not going to happen. This committee is going to be asked to go and visit the fishermen over there and the farmers over there and the barber in the barber shop and the butcher and the baker and the candlestick maker, apropos of nothing, without a context. And not much will get done. That being said, you can't say no, you have to participate and you have to do the best you can, which is what I'll do, and I have some ideas. But whatever you come up with, 2/3 have to vote to agree. And that's not going to happen in a meaningful way. They can't even agree on a chancellor. They can't agree on a chief justice. They can't agree on a chairman of the elections commission. This country is stuck, and the only solution is a majority opposition in parliament.
Now, in the United States, and I only quote the United States for good examples, if Congress and the Senate, well, Congress of itself includes the Senate and the House of Representatives, pass a law, and the president vetoed that law, it goes back to the Congress. A 2/3 majority in Congress can make that become a law. If in Guyana Parliament passes a law, let's say there's a minority government, or whatever, if Parliament passes a law and the president refuses to sign that law into, what happens?
That's a good question. And in fact, a law doesn't take effect until it is assented to by the president.
Right.
And we have had cases where the Ramatar government, the president has refused to assent to laws that they had reservations about. One example is the Judicial Review Act, which was a very important act that expanded the role of the court in assessing and reviewing conduct of government in the exercise of its powers to make sure it's lawful. There is a procedure that when it goes back, Parliament looks at it again and then it moves forward. And that is one of the areas where we, if we could get 2/3 in Parliament, the president's power needs to be removed in terms of his ability to interfere with parliamentary procedure simply by refusing to assent to a law. He shouldn't be able to impose that stumbling block on what should be an independent institution, but it's there. But it goes back and then it goes back to him again.
Mm-hmm.
Now, Dr. Blackburn, you know that in the States, Congress acts as a check on the president. The president acts as a check on the judiciary by appointing judges and so forth. I don't think we have that system in Guyana, but do you think that's a good system where one body can check on the other body?
No, I think the, I think in American context, the sort of legislative checks where the legislature checks the executive. We've seen these things refuse to pass laws or budgets that are proposed by the executive. So Biden has to go to the speaker. The legislature can impeach. I mean, sometimes they use this power. They use this power in some political way, but it can impeach and remove people from the executive branch. It can also check the judiciary by impeaching and in some sense defining the jurisdiction of the courts, right? So, as you've just described, our executive can veto the legislation. They can bring the legislature into some special sessions. They get to appoint the judges, right? So the president gets to put the Supreme Court judges in place, and then the judiciary can as Attorney Jonas noted, that they can declare laws that have been passed by the legislature not in compliance with the Constitution and nullify them. So this idea of checks and balances is an extremely important thing, and I think it would be good to see to see a kind of emergence of more checks and balances within the context of Guyana. It's important to have this kind of, I think as I've listened and I've gone through this, it's clear that you in as much as we have a democracy in which people have voted, but the democracy needs to be also kind of affirmed by the institutions, and so the institutions also need to have some democratic character. And I think if you're able to simply every day sort of hammer through your idea on a one vote parliamentary majority, then I think that's the rule, that's the game that you're playing. But I think that you need some wisdom, and this is actually the point where I wanted to raise with Timothy in this sense. He's kind of a bit pessimistic of saying, well, look, this thing can't change. The only way this thing changes in the near term is you have to have a third party that occupies enough seats so as to ensure that the government, so to speak, is a minority in the parliament and therefore has to negotiate with the opposition in this. And I think that that's what will fix it technically. But I also think that there's a certain sense of maturity and wisdom that needs to come to our political class in this moment, right? We have to recognize that this thing is unstable. It is unstable. We can see the signs of the instability. I mean, the good thing is that Guyana is not some place where people. The good thing about us is that we hold together in some ways that are, historically good. We're not at each other's throat. We kind of live and work with each other, and we're part of each other in some very important ways. But it's still unstable, and I think that at some point there has to be, and this is not. It's not a criticism of anyone, but there has to be some members of the broader political class in the dominant political parties that begin to look at this and say, as we look at Guyana in 20 years, 25 years, 30 years, 40 years out, that this is an unsustainable model. And let's sit down and think through what would be a sustainable model. What would be a sustainable political model for us to work with? It's not working for us. And it's gumming up our judiciary. It's gumming up it's gumming up our executive function. It's gumming up, which we haven't said anything. It's gumming up our negotiations with our teachers at a crucial moment. So at some point, something has got to give. And it seems to me that I still hope somehow that there is some wisdom in the political elite that says, look, sit down and think about how we make this structure better for us and less unstable for us over a long period of time. So, while I think, yes, you want the third party, I'm also thinking that when we say that, we take the responsibility for leadership of the country off the hands of the political people, and we pretend that, well, there's nothing you can do. You just have to continue running the ship in the way that you have to run it. And so I want to put that also on the table for us to consider, that the political leadership has a responsibility to make Guyana less unstable. And so it's part of their job to figure out. That's the job of it's part of what the silver tongue needs to be used for, to come together and try to find a place where constitutionally things look better.
Great, good.
I'd like to respond to that if you don't mind, Oscar.
Go ahead.
You see, one thing I've noticed with my good friend Dr. Blackman is that he hopes for the best from people. And unfortunately, as long ago as 3,000 years ago, the ancient Greeks were warning us that the rule by democracy means leadership by the worst among us. And it's all well and good to throw out a hope that these people who have scrambled their way into power by holding on within the party and relying on the race vote, that they will be altruistic enough and benevolent enough and well-intentioned enough to set aside personal greed and personal ambition and personal hubris and run the country. We haven't seen that happen, I'm afraid. Burnham didn't do it. Jagan didn't do it. Jagdeo didn't do it. Ramatar didn't do it. We have not seen it happen. What we've seen is self-important, puffed up people becoming inexplicably wealthy, first of all, also driving around in nice vehicles, preening, being first-class citizens, talking down to their supporters. But I would challenge anyone to point to a single good economic plan, a single good structure, a single good development that any of them can point to say, look what I've done, look what I've accomplished. The English left us with a system that was a large snowball rolling down a hill. And since independence, we have been rolling on the momentum of that without contributing anything from our leadership. And the ball moved more and more slowly as our economy declined from one of the more advanced in the Caribbean, one of the more developed Caribbean countries, to the poorest next to Haiti. That's all our doing. That's nobody else's fault. And by sheer blind luck, oil and gas is now here, so that there's a huge amount of money. And what policies are we seeing? Gas to Shore project that is already 2 times over budget, that is, no one has explained it, how it's going to work, which is just a follow-on from OMI, from Skeldon, from fiber optics from Russia, a series of failed projects. Meanwhile, GPL is not delivering as it should. Gaiwa is not delivering as it should. With our GDP, how do we explain that every single house in Guyana needs to have its own black tank? Go to London, 10 million people, you see any black tanks? Yet here we are. We have ruined and continue to ruin through our leadership, through poor leadership. And I do not hold out a hope that one of these gentlemen or one of these ladies is going to suddenly emerge from within the PPP or out to save the day. It's not going to happen.
That's a good idea to raise these black tanks. I don't understand why we have to have black tanks, but anyway, that's a different topic. Now, I want to go to something here, and I want to hear both of your comments before we get to the strike. Separation of powers is under severe threat from 55 countries around the world, especially the judiciary, which is faced with government interference in favor of a politicized judiciary system. most judges' appointments are bordering on their political views or their party affiliation. Now, to my surprise, those 55 countries, Guyana is included. But I don't know under which government they include Guyana on that. But your comments is that most judges are appointed bordering on their political views or political affiliation. Dr. Blackman, what do you think?
No, I can't speak to the precise process of the appointment of judges in Guyana, but I think, just from the American context, I think we would, as we noted, it is the executive branch which appoints judges, and so
No, to the Supreme Court and federal judges.
And in the local, say here, if I'm a judge in Brooklyn,
are the governors, and some judges are elected.
And then in a large part, this is a political contest in which I need to, align myself with either A, the Democratic Party, or B, the Republican Party. So there's a political dimension to judges. One hopes that, given that they rise to the occasion. So I'm not surprised that something like this. I wouldn't be surprised if, the United States. I mean, for example, we looked recently at the appointment of, conservative judges to the Supreme Court, and part of the outcome being the reversal of Roe v. Wade and questions of abortion. So I think that in some ways there is an ongoing political battle about the kinds of judges that we want on the bench, and one would hope that this would not be the only factor that determines the quality of the judge on the bench. So I'm not surprised that there's some political dimension. It's clear in the process that there will be a political dimension to the selection of judges.
Mr. Jonas, you believe in that? Or that judges should be appointed bordering on their political views or political affiliation?
The system of appointment in Guyana, again, the structure looks good, but it has its weaknesses. At the end of the day, after you get rid of all the noise and the chaff and all the fancy language, our Judicial Service Commission, the majority is appointed by the government. Indirectly, yes, but this is our turn and that's how you have it. So there is that control, the majority. Now, the fact is, though, a large majority is independent or opposition. So in the discussions in the Judicial Service Commission, to which I have never been privy, I'm sure that there's quite a heated debate. And the fact is that the people who sit there, however politically entrenched they might be, they are all professionals. All of them have the background and the qualifications to make their assessments. So I suspect that the discussion is also collegiate. Now, what I have seen here is the refusal by the president sometimes to confirm people. In fact, we have had to threaten litigation with some judges back 20 years ago, 15 years ago, that had been acting, although they had been recommended by the Judicial Service Commission, they had been acting because the government refused to confirm them. Now, that's always dangerous because there's no security of tenure. If you're acting, you could be fired anytime. And a judge needs to be secure that when he gives a decision the government doesn't like, they don't fire him. So he must be confirmed. So there is that interference as well. But at the end of the day, I think that you cannot get away from the fact that although a judge, and our judges are professional and have a sense of pride, professionally speaking, none of us is politically neutral. All of us have that bias. And there's another thing that you can't escape. The writer Selwyn Ryan said it, and in a speech Fitzpatrick said it. Judges are human. They want to be promoted. They want to go to Court of Appeal. They want to be made Chief Justice. They want to be made Chancellor. And the way to do that is not to be controversial. Any fool knows that. So I have had the personal experience of a former Chief Justice. My client overheard him after a matter was over, walking down the passageway, the corridor of the court with the Attorney General, and saying, "Man, I put in for my duty-free concession and it hasn't come yet."
Wow.
That's intolerable. So if the politicians have a say in who is going to be promoted, then some judges, they will see that their star rises very fast because they are or are perceived to be loyal. Whereas other judges who may be equally competent, their stars fall. And we have seen that reversal over the years. It's not the judge's fault. Often it's perception. They need to be divorced as much as possible from the executive. And I support adopting a part of the American system. I believe the judges should select from among their number their own Chief Justice and their own Chancellor. That body of judges know who they respect. They know who works hard and who pulls their weight. And they know who has the administrative skill and the tact and the diplomacy to carry the judiciary. Let them appoint it. Take it away from the president and the leader of the opposition, who for 20 years have not been able to agree on those subjects. If you give it to the judiciary and you let the judiciary do it, you got an independent judiciary. That's what we need, independence.
Great. What's the retirement age for a judge in Guyana, Jonas?
I think it is, you're asking me some questions out of left field here. I know that I think it's like 55 for the High Court, and then maybe 60 for the Court of Appeal. It's a bit tiered that way. So you get extra years if you're in Court of Appeal. And then I think again in the CCJ, it's even higher. It might be 62, 65, 68. It's something like that.
Okay. Now let's go to the strike, teachers' strike. For the first time, I think a judge has ruled that teachers who are on strike are supposed to get pay. We know all over the world when people go on strike, they're not supposed to get pay. But he made the ruling because he said that the government refused to negotiate with the union. So the teachers' strike was valid or had become validated because the government just go over the union's head and issue a blanket increase to everyone, public service 6.5% or whatever. And he's saying that's wrong because you just state that you must negotiate with the workers' representative. Mr. Jonas, do you agree with that?
The Attorney General has expressed that he doesn't agree and he proposes to appeal. And I've said in another forum, the Attorney General is a competent lawyer and has a right of appeal, which is given to us in the Constitution as part of a wonderful system inherited from the British. And I support and welcome his decision to appeal. I think what's more important, however, is that we consider the moderate and respectful language used by the Attorney General quite properly. In contradistinction to words like presumptuous, used by Barra Jagdeo to describe the decision, and to say, who said that the judiciary needs to remember that it is separate from the executive and the executive is independent, and the judge's decision was presumptuous. That is not acceptable.
Dr. Blackburn?
No, I can't speak to the technical aspects of the decision of Justice Kassian, but I certainly can affirm sort of the guidance as we. I mean, look, we are looking now as part of our news things of the trial of former President Trump, and the judge we just listened this morning issued a gag order in terms of the kinds of comments that you can make about the judiciary and about the judges and about the people who are participating in them. And he fined Trump, I think $9,000 or something for these violations of the gag order. So I certainly think that it's incumbent upon all of the political actors, the people who are part of the executive, to be mindful of the choice of words that are used to describe judges and judicial decisions, so as to ensure that this institution is allowed to function in the way that it should be. I think So I'm in agreement. Perhaps the use of the word presumptuous for the judge might not have been the appropriate characterization of how it might not. It certainly was not the appropriate characterization, given the role that the judiciary plays, as we have been discussing here this evening. You know, the point I wanted to make about this question about the teacher strike is something that was you know, something that we raised the last time Attorney Jonas and I participated in this discussion. The strong issue, I think, is that Guyana's got to see, and the people who are, again, I know Mr. Mr. Jonas accuses me of being of hoping for the good in people. But I'm hoping for rational. I'm hoping for people to look at a set of policy pathways and to choose the policy pathway that makes the best sense for Guyana. I think you have to expect that from your political leadership, in as much as they have not been able to do that over the course of many, many years. So I think in this issue, I think Mr. Jonas raised this issue the last time. Is what kind of country do you want? Do you want the people in Guyana to occupy only the service industries and that kind of work, or do you want us to be, you know, in a very real sense, owners of Guyana? And if you want Guyanese to, quote, own Guyana in a substantive way, then they have to be educated in a really rigorous and robust manner. And so the education sector is, in some sense, the most important sector of your, you know, public sector. And so this situation where, you know, you have disagreements over whether you're going to go from 2019 to 2023, whether, you know, it's going to be 20% or 25% or 6.5, or, you know, it seems to me that, again, I think we're letting the political leadership off the hook by saying, this is your job. This is what you're supposed to do. You're supposed to come to an agreement with the union. And I think that that's what the judge is in some way reflecting. This is part of your job. This is part of the experience. You're supposed to do this because this is what you were elected to do. And so it seems to me that that's the strategic choice. It's less about the particular details here, but the strategic choice about what is the role of the education sector going forward. How do we envisage Guyanese, the role that Guyanese will play in the society going forward? And understanding that education is key to that, and your teachers are key to that. And so it's incumbent upon the decision makers to come to a proper agreement with the teachers, right? It's gone on too long. It really has gone on too long. I mean, you know, my mother was a teacher, so I know this business. So teachers are not people who are sitting there, getting wealthy, right? I mean, teachers are people who are getting up every day. So, I mean, it seems to me that there's a real responsibility here on the part of the negotiators to sit down and come to, and I think that that's what the judge was reflecting. If I were to read what he was, I think he's reflecting, look, guys, come on. This is the time for us to be adults in the room and to do the job that the people of Guyana elected us to do.
That is true. We're supposed to be adults, but sometimes we're not.
Yeah.
But I think Justice Sandil Kissoon maybe read Justice Brennan in the United States ruling. When Ronald Reagan was elected to office, I think 2 years after, the air controllers in the United States, across the United States, went on strike because negotiations broke down. He fired all of them. So supervisors and managers had to be manning each airport air control system. And they had near misses and crash and so forth, but there were no crashes. The air controllers union took the matter to the court, and Justice Brennan ruled that they have to be paid and have to be reinstated.
Yeah, I do think that, you know, it's time for the parties to reach an agreement. It's time for this matter to be closed, and it's time for the people who are responsible here to step up to the plate. And I think that that's in very strong language what the what the judge, maybe I can't speak to, you know, the legal rationale, etc., but I can speak to just reading sort of a judge saying, I have some responsibility to the broad society. I recognize the importance of education and the education sector, and I'm urging the parties that are involved here to do the right thing, i.e., come to some agreement that moves their society forward, and that's my read of it.
Mr. Jonas, we're coming to the end of the program. On a scale of 1 to 10, how effective you think the separation of powers in Guyana is?
I think that the judiciary is as independent as can be expected given the constraints. I think that Parliament is owned by government and will continue to be owned and controlled by government, so there's no separation there until a third party intervenes, and that is where we are falling down. Once the government makes the laws to maintain itself in power, to give itself control of the purse strings, as we are seeing happening, we will continue to have the elected dictatorship that we have had throughout our history. There needs to be a
So, you give on a scale of 1 to 10, 10 being the highest.
Was that question directed
No,
to me?
Mr. Jonas,
Okay.
what rating would you give the system, separation of powers?
Well, you could, again, I resist a simplification like that. You're asking me for a number between 1 and 10, whereas
Yeah.
I've said that the judiciary is independent, so they would get a higher score, but Parliament is not independent, so they would get a lower score. So I don't want to just give you a number so that we can carry it to the United Nations like they like to do, and put you on a scale and say this country is third most corrupt and fifth most corrupt. I prefer to have a more informed approach. I think our judiciary is as independent as can be expected, and I think Parliament is not independent, and that needs to change. And it cannot change if there are only two parties contesting.
But that's what the parliamentary system gives. Any country, the parliamentary system, the party with the most seats in parliament controls parliament. That's a given. Mr. Jonas.
I hear you, but Guyana has its own peculiar dynamics. You see, what happens in Guyana is because each party is representative and represented by a racial group, a specific race group.
Right.
There's no deviation. There's no crossing. I could vote Democrat this election, vote Republican next elections. I could vote conservative this time and vote liberal next time. But there is an identification with each party that is race-based. So we have to look at our own particular dynamic and understand that as long as that is how we're voting, merit doesn't come into the story. In 1992, half of Guyana, nearly half of Guyana, still voted PNC. In 2015, nearly half of Guyana still voted PPP. And in 2020, nearly half of Guyana still voted for Granger. We don't care. We will vote along ethnic alliances. And therefore, the question of merit, whether you run the country well, whether your economic, social, health policy was good and successful, doesn't even arise. And that's our danger. That's why we have to separate Parliament per se. Because an unhappy population next election who says, you didn't choose your majority in Parliament, well, we voting you out, that doesn't arise in Guyana. There needs to be a separation.
Dr. Blackburn, your closing remarks.
Well, I suppose so. There are two things I wanted to say. So, you know, let me take 2 minutes. So, there's issue that Attorney General Timothy just raised is precisely the point is, why are these things not working? And I strongly believe that these things are not working because it's a question of education. And while we were talking, I sort of reached out and looked up the Guyana labor force participation surveys. And so these, I'm going to give you what it says from 2020. This is percentage share of working age population by level of education completed. And this is 2020 first quarter and 2021 first quarter. So this is where we are. This is a snapshot of where our working population is in this moment. 9% no schooling and early childhood education. 46.1% primary education. Upper secondary education, 23.6%. Post-secondary, 4.0%.
Yeah.
Bachelor's or equivalent, 2.5%. Master's or equivalent, 0.2%. Doctoral or equivalent, 0.1%. I submit to you, Dr. Rhodes, that the issue that these issues of, or gummed up judiciary, executive branch, etc., these issues are inextricably linked to the question of what our working age educational profile looks like as a country. And it's this reason why I'm saying that, I enjoy this conversation with Timothy Jonas because, he gets the point. He's a skeptic, but sometimes I think he kind of tips over and becomes a cynic. So I have to believe that there's someone in Guyana who's sitting there. Paris. What's that? I have to believe that there's someone there who is sitting, saying, "Look, let's make this right." And I think you have to start with this business of just making the teachers right. I mean, it's just, it doesn't work. I don't understand somehow, and this is where I think Timothy and I, maybe, Timothy's thinking they're not going to fix this. And he did say this. I must confess, he did say this when we first spoke. He did say, at this point we were all a little optimistic about the ruling and the fact that they were going to go meet. And he did say at that point that, look, this thing is going to, I'm very appreciative of, but I caution you. But I'm saying at this moment, we have to hold the people responsible. We have to hold them to a higher standard. And maybe that's my closing remark. Given where we are today, given where we're sitting relative to our oil and gas industry, we have to have a strategic direction. And that strategic direction has as its basis education. And so we have to come to some kind of arrangement with our teachers. I think that's and I hope, I want to be skeptical like Timothy, but I don't want to tip over being cynical and sort of thinking that it can't ever happen, that the people who are there can't negotiate in good faith with the teachers.
Negotiations call for compromise. Thanks. Mr. Jonas, your closing remarks?
I would like to thank Terence for remembering that, because I know he hopes for the best, and I know he tries to turn a blind eye to the reality of things. But I did say that the mediation, which brought the teachers back to the classroom, also took the wind from their sails, and it would be hard for them to go back to strike when the talks broke down, as I knew the talks would break down. We try to pretend it's not political. And let me tell you, the teachers have a real grievance. And at the level of the teachers, the politics and the race is not in it. It's from both sides of the divide. I've spoken to the teachers on both sides of the divide. But when you ask, is it political? I therefore have to say no. But then when you take it to the higher tier, which is the union is an APNU supporting union. Because at the end of the day, the public servants and the teachers as well are majority Afro-Guyanese and majority APNU supporters for that reason. So if you look at how they conducted the fight, the government who is in charge that they're fighting against, at that level, it suddenly becomes political, and we can't escape it. So if you ask me at that level, is it political? Of course it's political. And what's the end result going to be? Is there a meeting of minds? Does the government want to look weak and say to these people here, take what you're asking for? No kickback in that, I'm afraid. No benefit in that. They're not going to change their vote and vote for the government. This government has learned from their hard effort in Linden to win votes in the local democratic elections. The Afro-Guyanese not voting for them, and they're right. And the Indo-Guyanese not voting for APNU, and they are also right. Because both governments, both parties are intrinsically, inherently biased in favor of their own in the way that they conduct governance. That's the truth. So is it political? No. Honest, hardworking teachers are mistreated. Is it political? Yes. Because at the level of the representation and where the political discussion happens, it's all political. That is Guyana's rot.
Gentlemen, we'd like to thank you all very much. At least you all put light on a lot of issues, and I think you all educate our listeners to a large extent on the separation of powers. And that's great for our listeners to know and understand. So once again, I would like to thank you all and thank Noir Singh for making this program available, Devin Bissoon and Ryan Gobin as well. And to all our listeners and sponsors, a special thanks to all of you, because without you, we cannot continue this program. So once again, thank you. Thanks to Mr. Jonas. Thanks to Dr. Blackman. And I hope to get you all back again. You all make a very good partnership here in the discussion.
Thank you very much, Asquith. I hope you keep inviting PPP members, and maybe one of them might turn up one day. We can't have a conversation in an echo chamber. There needs to be somebody answering back.
I tried to get, I spoke to about 5 of them, and they all turned me down, said that they're busy preparing for the Congress and want me, they don't want to debate with any one of you and so forth. So there are different reasons given to me. But I hope sometime we'll have them, maybe in a few months, and we'll have this discussion again. So thanks again to both of you, and again to all our listeners. Thank you very much. Good night.
Thank you.
Thank you.